There is a hidden playbook. And no, your local attorney has almost certainly never shown it to you. Not because they don't know it exists, but because the people who use it don't want you to know it exists. Right now, somewhere in a glass office overlooking a city you probably can't afford to live in, a team of attorneys is building a wall around someone's wealth so thick, so deliberately constructed, that even a federal court order struggles to touch it. They own nothing on paper. They control everything in reality. And if you think that kind of protection is only for billionaires, I need you to stay with me for the next 15 minutes, because by the end of this video, you are going to understand the exact structural layers these people use, and you're going to see precisely how a scaled-down version of this architecture can be built around your life. This is WealthForge. We don't follow the market. We design the moat. In a world of followers, we are the architects of our own freedom. Let's build. The illusory nature of direct ownership, why having things is the most dangerous game you're playing. Let me ask you something blunt. What do you actually own right now? Your house? Your car? Your investment accounts? Maybe a business? Now let me tell you what a plaintiff's attorney sees when they look at you. They see a target. Because in the United States alone, there are over 40 million lawsuits filed every year. That's more lawsuits per capita than any other nation on the planet. And the moment your name is attached to assets, real estate, equity, cash, you become someone worth suing, whether you did anything wrong or not. Here's what the ultra-wealthy figured out decades ago, and what's been quietly refined ever since. Direct ownership is a liability. Structural control is an asset. The moment your name appears on a deed, a brokerage account, or a business registration, you have handed a roadmap to every creditor, every opportunistic litigant, and every divorce attorney on the planet. But here's the shift, the architectural shift that separates the people who build generational wealth from the people who spend their lives one lawsuit away from losing everything. You don't need to own your assets, you need to control them. This isn't a gray area. This isn't a loophole. This is the foundational legal framework that Rockefellers, tech founders, and real estate dynasties have operated inside for over a century. And in 2026, this has become even more critical because new transparency regulations, specifically the Corporate Transparency Act and expanded FinCEN beneficial ownership disclosures, have forced a pivot. Simple shell companies, gone. Too exposed. The new architecture is multi-layered, it's deliberately complex, and it's built to make your personal identity legally invisible from your financial footprint. That's what we're deconstructing today, layer by layer. The architecture of the master holding company, building the mothership. All right, let's talk structure. The foundation of every sophisticated asset protection plan starts with what I call the master holding entity, and the jurisdiction you choose to form it in matters enormously. Wyoming, Nevada, Delaware. These three states are not equal, and most people default to their home state, which is one of the most expensive mistakes they never see coming. Wyoming, in particular, has become the gold standard in 2025 and 2026. Here's why. Wyoming LLCs offer charging order protection as the exclusive remedy for creditors. What that means in plain English, if someone wins a judgment against you personally, they cannot seize your LLC interest. They cannot step in and run the company. All they get is the right to sit and wait for a distribution, which you, as manager, never have to make. You heard that right. A creditor can win in court and still walk away with nothing, because the structure itself is designed to make winning meaningless. Now, the master holding company is not where you put everything. That's a common critical mistake. The master entity is the mothership. Its job is to catch and redirect cash flows. It's the central commandant. Below it, you build subsidiaries. Here's why this matters. Imagine you own three things: a short-term rental portfolio, a consulting business, and a block of appreciated stock. If all three sit under your personal name, or even under one LLC, a lawsuit against the rental business can reach your stock. A client dispute and the consulting firm can threaten the real estate. Everything is exposed to everything. But when you practice asset segregation, separating high-risk operating businesses from high-value passive assets into distinct entities, you build a firewall. The rental company gets sued, the lawsuit hits that entity and stops there. The consulting firm's liability cannot touch the investment holdco one layer up. And here's where it gets genuinely sophisticated, a technique the ultra-wealthy call internal debt loading. The operating subsidiaries are structured to owe money, legitimate, documented debt, back to the holding company. On paper, from the outside, the operating entities look undercapitalized. They look like they have no money worth taking, because legally, they don't. This isn't fraud. This isn't deception. This is architecture. Deliberate, documented, legally sound architecture. And in 2026, the smartest operators are running these structures through registered agents with layered management agreements that further separate their personal identity from the paper trail. The irrevocable trust as a legal fortress, separating who you are from what you have. Now we go deeper, because if the holding company is the wall, the irrevocable trust is the moat. And this is where most people, even successful people, have absolutely nothing in place. A domestic asset protection trust, or DAPT, is one of the most powerful legal instruments available to U.S. residents who want to separate their legal identity from their net worth. Here's the core concept. When you transfer assets into an irrevocable trust, those assets are no longer yours. You are no longer the owner. You are a beneficiary, and in many cases, even that beneficiary status can be discretionary, meaning no one can force the trust to distribute assets to you on a schedule a creditor could intercept. The trust owns the assets. A carefully selected independent trustee manages them, and a trust protector, a separate party, holds the power to modify, amend, or even move the trust if circumstances change. This matters enormously in a divorce, in a personal lawsuit, in a bankruptcy proceeding, because when the attorney for the other side starts looking for assets to attach, they find a trust. And the trust's assets are not yours. You don't control them. You can't unilaterally access them. And depending on the jurisdiction and the trust's seasoning period, a creditor may have as little as a 2-year window to challenge the transfer, after which it's untouchable. Alaska, South Dakota, and Nevada are the leading DAPT jurisdictions in the U.S. right now. Each has its own statute of limitations, spendthrift provisions, and self-settled trust laws.
But here's the development that's reshaping the space in 2026. Smart contracts within trust deeds. Forward-thinking estate attorneys are now encoding trust distribution logic into blockchain-verified smart contracts, creating automated, auditable distribution rules that operate outside the traditional probate system entirely. Think about what that means. Instead of a probate court spending 18 months unraveling your estate, the trust executes automatically, according to rules you built, in a jurisdiction you chose, at a speed no court can match. This is the architect's advantage. Offshore jurisdictions in a transparent world, the last hard stop. I know what you're thinking. Offshore? Isn't that just for people hiding money from the IRS? Let me be direct with you, because this is one of the most misunderstood areas in wealth protection, and the confusion costs people millions. Offshore structures, when used correctly, are not about tax evasion. That's illegal. What we're talking about is jurisdictional arbitrage, the legal strategy of placing assets in countries whose liability statutes, court systems, and creditor laws are simply more favorable than what you'll find domestically. And in 2026, with FATCA, CRS, and expanded FBAR reporting, the era of anonymous offshore accounts is genuinely over. But 2 jurisdictions remain extraordinarily powerful, and they're worth understanding. The Cook Islands and Nevis. Here's why they're different from everything else. A Cook Islands trust is virtually immune to U.S. court orders. A domestic court cannot compel a Cook Islands trustee to release assets. The plaintiff would need to relitigate the entire case in Cook Islands courts, under Cook Islands law, with Cook Islands attorneys, at a cost that makes the entire exercise economically irrational. That's not a loophole. That's a feature of an independent sovereign nation's legal code. And embedded in these trust structures is something called the Duress Clause, a provision that automatically prevents asset distribution if the grantor is under any form of legal or physical coercion. So if a domestic court orders you to instruct your trustee to return the funds, the trust reads that as duress, and it refuses. You are not in contempt, you genuinely cannot comply, because the trust won't let you. That is the last hard stop, the wall behind the wall. And for professionals, physicians, business owners, real estate operators who face elevated liability profiles, a properly structured offshore trust layered beneath a domestic holding company structure gives you a level of protection that most litigation teams simply will not pursue. The math doesn't work for them. Active defense and the art of litigation fatigue, making you not worth suing. Let me bring this home, because the final layer of what the ultra-wealthy do isn't about structure at all. It's about strategy. Specifically, it's about making the act of suing you so expensive, so uncertain, and so procedurally exhausting that rational adversaries walk away before trial. Attorneys call this litigation fatigue, the practice of creating so many procedural obstacles, jurisdictional questions, and structural ambiguities that pursuing a case against you costs more than settling. Here's how it works in practice. When a plaintiff's attorney evaluates a case, they run the math. What's the likely judgment? What are the assets I can actually collect? What will it cost me to get there? When your assets are held in a multi-layered structure across a Wyoming LLC, a Nevada holding company, a domestic DAPT, and an offshore Nevis trust, that calculation becomes very unfavorable to them very fast. They know they're looking at years of litigation, jurisdictional disputes, trust challenges, and at the end of that road, a Cook Islands trustee who won't pick up the phone. Most cases settle or get dropped entirely. And for the cases that do proceed, the ultra-wealthy use private settlement funds and pre-arranged arbitration clauses embedded in every contract they sign. Disputes get routed to private arbitrators, out of public record, out of jury trial territory, controlled, quiet, and resolved on terms that don't become headlines. Now, the obvious question: Dr. Ben, I'm not a billionaire. Can I actually use any of this? Yes, and this is where I want you to pay very close attention. You don't need the full architecture on day one. What you need is what I call the Billionaire Light Blueprint, a scaled, practical version of this structure designed for professionals, entrepreneurs, and serious investors building real wealth. It starts with 3 moves. Move 1, form a Wyoming LLC today. Move any business income and investment assets into it. Get your name off the direct ownership line. Move 2, open a conversation with an estate attorney about a domestic self-settled trust in Nevada or South Dakota. Even a basic irrevocable life insurance trust, or ILIT, moves significant assets off your personal balance sheet legally and immediately. Move 3, implement asset segregation. If you own a business and real estate, they should never share the same entity. Full stop. These 3 moves won't make you untouchable, but they will make you a dramatically less attractive target. And in the current legal climate, that is the most important thing you can do for your family's financial future. Here's the truth that nobody says out loud. The wealthy aren't richer because they earn more. They're richer because they lose less. Every lawsuit that doesn't reach them, every creditor that walks away, every estate that transfers without a probate fight. That's the game beneath the game, and the people winning it aren't doing it with better stocks or smarter trades. They're doing it with better architecture. At WealthForge, we don't believe in chasing markets, following trends, or hoping the system works in your favor. We believe in building structures that work regardless of what the system does. Because we don't follow the market, we design the moat. And in a world of followers, we are the architects of our own freedom and subscribe.
If this opened your eyes, I want you to do one thing. Share this video with someone who owns a business, who's a physician, who's a real estate investor, someone who has something worth protecting and no structure around it yet. And if you're serious about building your own billionaire light blueprint, drop blueprint in the comments right now. I read every single one. I'm Dr. Ben. This is WealthForge. Build the moat, protect the castle. See you in the next one.